Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense,
Yes.
you said that's one of the built-in protections and
Yes.
why immunity is not necessary. Because in
Yes.
some of these instances, when the president takes such actions that, you know, the court's been asking you, might this result in criminal prosecution, you say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function.
And therefore, I acted lawfully.
Therefore, I acted lawfully and
Yes.
I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get out of jail free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved in the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a Supremacy Clause issue, and the court would run a Supremacy Clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the Supremacy Clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean,
well,
that's my point. Like, you know, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system, one thing that we have to worry about. That might not carry the day, but, you know, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of Supremacy Clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient?
Yes.
the special counsel has expressed some concern for speed and wanting to move forward. So, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity, and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components, as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding, is private campaign activity, we still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that evidence can be used even if culpability can't rest on it.